Hi, and thank you for being here today. My name is Dan Gorenstein. I'm founder and executive editor of Tradeoffs. Tradeoffs is a nonprofit news organization that covers healthcare's toughest choices. We produce a weekly podcast called Tradeoffs, which you can get wherever you find your podcasts. And, you know, there have been a lot of fast and furious changes in healthcare over the last year and a half. Many of you know this, and it can be hard to make sense of all of this that's happening. That's why we've partnered with our friends at the Leonard Institute of Health Economics at the University of Pennsylvania for a series of conversations that we call Decoding the Moment.
And I am Rachel Warner. I am the executive director of the Leonard Davis Institute. LDI is Penn's hub for research on healthcare delivery, population health, and health policy. We bring together more than 500 researchers who are national experts and thought leaders on health and healthcare. We're coming together with trade-offs to create a place where you all can better understand what's happening in Washington, D.C. and what it might mean for our future. Today, we're taking a closer look at a rare bipartisan health policy win from the first Trump administration and how it seemingly has gone a bit sideways.
We're talking about the No Surprises Act. Congress passed the hugely popular law in 2020 with two goals: shield patients from unexpected medical bills and lower the high prices charged by some doctors. One of those goals is going great. Patients are now protected from bills that occurred after going to a hospital that was covered by their insurance in network, but inadvertently got care from doctors out of network. But new academic research and reporting from the New York Times suggests that the second goal is falling short. Some doctors are now getting exorbitant payouts, charging insurers so much more that it may be fueling higher premiums that we're all paying. Joining us to talk about the No Surprises Act and what a fix might look like are two of the country's top researchers on surprise bills and a former official from the Centers for Medicare and Medicaid who helped write the rules for the law. We asked for your questions in advance, and more than 50 of you submitted them with your registration. Thank you so much for that, and a clear sign of real interest in this topic. Please talk up the other folks in the chat. We hope that part of what we can do through these events is help you all connect with each other and learn from each other. To initiate that, please jump into the chat, introduce yourself, and maybe what you're hoping to learn today. While you do that, I'm going to turn it back over to you, Rachel, to get us started with one of my favorite parts of these decoding episodes, which is three big numbers.
Thank you, Dan. So here are three numbers that succinctly tell the story of what's happening with the No Surprises Act. The first number is 20 million. That's the number of bills that were out of network in 2024 that could have resulted in a surprise bill. Now, to be clear, it's impossible to know how many providers would have actually sent a surprise bill. But the point is that consumers are now protected from the kind of unexpected bill that comes to you when you go to an in-network hospital or emergency department, but get treated by an out-of-network doctor. The second number is 88%. Multiple researchers have found that doctors are winning more than 80% of their arbitration cases, a system that was set up by the new law, when out-of-network physicians can dispute how much an insurance company offers to pay. And the final number here is 2.7. That's one estimate of how much more, on average, providers are getting paid in these arbitration cases compared with the typical or median in-network rate for some of the same services in the exact same markets. So, for example, we've seen a doctor get paid $330,000 for a diagnostic test that usually gets reimbursed at a rate of $2,600. So those are the three numbers, Dan. And the last two are why people are concerned. This arbitration system, as it's currently working, heavily favors providers, and it's delivering some huge payouts. That's not how the system was designed to work. Today, we'll get under the hood and figure out what happened and where we can go from here.
Great. Thank you so much for that, Rachel. So we've got one number that reminds us that the law is actually protecting millions of patients, just as intended. But the other two show that something seems to be going awry in the arbitration part of the law, which could cancel out the law's goal of lowering healthcare costs. Now, I would like to turn to our panelists. So if you guys can come off or make yourselves visible like magicians. And these are some of the best folks, as I mentioned before. These are some of the best folks you could hope to have a nuanced, evidence-based conversation about what the No Surprises Act is. And I'm going to let them introduce themselves. Lindsay, could you please start? Thank you.
Absolutely. Thanks, Dan. I'm Lindsay Murtaugh. I'm at the Brown School of Public Health in the Center for Advancing Health Policy Through Research. And here at Brown, my research focuses on private health insurance. But perhaps most relevant to today's discussion, prior to joining Brown, I worked at the Centers for Medicare and Medicaid Services, where I was one of the leads in the development of regulations to implement the No Surprises Act. So I had a front row seat as we attempted to take what Congress had passed and put it into reality.
And Ben, how about you?
My name is Ben Chartok. I'm an assistant professor of economics at Bentley University in Massachusetts, and I've been working on the No Surprises Act for the better part of a decade at this point.
Thanks, Ben. Zach?
Dan, it's good to see you.
Good to see you
Hi,
too.
everybody. Zach Cooper. I'm a faculty member here at the Yale School of Public Health in our Department of Economics. I also run the Healthcare Affordability Lab at Yale, and a lot of my research was the early days showing how often surprise medical bills occur, and then I was pretty hands-on as the law made its way through Congress.
Thanks for the introductions, you all. Thanks for keeping them short. I know everybody appreciates that, and also really want to thank you for being here and spending time with us and investing some time in this really important topic. Zach, let's start with you. I'd really like you to help us set the table because you're one of the first researchers to study the issue and really help put it on the radar of lawmakers. What was the problem that you and others identified?
Yeah, so it's really there's this uniquely American idiosyncrasy in our health system, which is that hospitals and physicians independently negotiate with insurance companies over the care that they provide, over their prices, over their network participation agreements. And if you're an internist, that's not a particularly big deal. But if you're a hospital-based physician, that's a really big deal. And so if Ben got into an accident, I hope he doesn't, but if he went to an in-network hospital, did everything in his power to get there, he could still be chosen or treated by an out-of-network physician he didn't choose and couldn't avoid. And that creates a bunch of problems. So the first and the most obvious is, well, what do you pay in that case? The physician's out of network. And that physician might try to collect their charges. And it might be that Ben's insurance company says, look, we don't cover out-of-network care to begin with. Well, then, Ben is not in a great spot. He's going to be facing a really big bill. Might be that Ben's insurance company says, okay, we'll pay, but we're going to pay what we usually pay for in-network care. And in that case, the physician might actually go after Ben and in that case, try to do what's called a balance bill him for the difference between what they were billing and what the insurance company paid. And this was happening really, really frequently. So I did a bunch of work showing that for emergency room care, thereabouts of 1 in 5 of the in-network visits that we saw, and Ben was doing similar research with other data, involved an out-of-network physician. And we were seeing similar incidents for other physicians. So you want to think about anesthesiologists, it's happening 10 or 15% of the time. Pathologists, similar rate. You saw it a lot with assistant surgeons. And then you also saw it with radiologists. And that gets us to the second issue, which is that these physicians, because of this sort of idiosyncrasy and how they were getting paid, were getting paid higher rates as a percentage of Medicare than other physicians because the bargaining structure changed. So if I'm an orthopedic surgeon, I, in a sense, have to be in network, right? If I'm not out of network, I'm just not going to see many folks. If I were an ED physician or an anesthesiologist, now there are some obligations because of EMTALA that I have to see patients. On the flip side, I don't have to participate in networks. And so their in-network rates sort of higher than other physicians' rates. And that really is what sort of gave rise to the No Surprises Act. I think the best way to think about it was this story that Libby Rosenthal wrote in 2014. It was about this guy named Craig Hopper. I still remember the guy's name because he was really the basis for a lot of my work. He got hit in the face by a softball, right? And the poor guy goes to the hospital, ends up getting a bill for $2,000. And that's really the impetus. It was those sorts of unexpected surprise medical bills that were just happening time and time again when people went to the hospital.
Routine care. Thanks very much for that very straightforward, clear explanation, Zach. And you and other folks took this data, Ben, took this data to lawmakers, and you said you have to do something. And specifically, as we mentioned before, a fix needed to accomplish two things: shield patients from getting these big bills and come up with a way to figure out how much insurance should have to pay doctors because the docs still need to get paid. And voila, Congress passes the No Surprises Act. Lawmakers initially wanted to require insurers to pay providers the median of what they pay to in network providers, the clinicians and hospitals they already have contracts with. But the providers pushed back, and Congress instead set up what's known as baseball style arbitration, a system to settle these disputes between the docs and the insurers. Zach, can you briefly explain how baseball style arbitration works and the theory behind why folks thought it would actually bring healthcare costs down?
For sure. And I'm going to add a third goal in there. So one of the mistakes I often made back in the day talking about it, and I want to make sure we don't make today, is talking exclusively about physicians. Because you have this idea that it's one doctor, and we've got this Viking doctor who's sort of shaking down patients for their
Did you
bills.
say Viking doctor?
Viking doctor, right? Super aggressive, right? They're out there with, whatever Vikings carried. It turned out there were a handful of physician staffing companies. So Envision and its subsidiary AmCare, Team Health, who's still around, and they had really sort of internalized this sort of idiosyncrasy as part of their business model. And so Envision Healthcare, and we showed it, the company eventually went bankrupt. They basically just had a policy of not really participating in networks. Team Health was actually different. They would pull out initially and then actually were mostly in network. And I think part of the idea with the No Surprises Act was to sort of discourage some of this sort of institutional out-of-network billing. There were different flavors of reform that we could have done. My personal flavor or favorite was saying, look, like it turns out people buy the hospital and the physician together, and we should just have that be the payment rate, right? Insurance companies should just pay hospitals and have the physician fee baked in. And nobody thought that was tractable. There are some other folks out there who said, look, we should just regulate the rates. And I'm an economist, so I don't adore price regulation. That got me a little nervous, and some other folks, agreed. Where we got to is baseball rules arbitration. And the idea is, what's the challenge? We don't know what to pay because there isn't a contract. So we've got to establish something that's pretty close to a market-determined rate. And so the insurer says, look, here's what I'm willing to pay. The physician says, look, here's what I want. And an arbitrator chooses what he or she thinks is the most reasonable amount. And I did some research looking at this in New York and found that in equilibrium, so on average overall, this actually lowered the in-network rates we saw to physicians. And I do want to sort of caution us, we don't really know what the effect is thus far of the No Surprises Act. We know that some of the arbitration payment outs are pretty high. And in some ways, that doesn't really surprise me because they were different cases to begin with. These are cases that by construction weren't settled. I think the jury's still out about the impact of the program. But the idea is basically if each party is disciplined in the bids they give and they can only submit one, you're going to get something that approximates an in-network payment. Right? So that was the idea. An arbitrator, you want as many of these cases settled as you can get. The ones where there is a dispute can go to arbitration. Each party submits a bid. Insurers what they're willing to pay, hospitals what they're willing to accept. The arbitrator chooses one, and that's it. That's our ball game.
No negotiation beyond that.
And you can't even take it to court, right? Once the arbiter has said, boop, I've issued my ruling. That's the amount, and you have, I think, 30 days to pay it.
Great.
So that got codified. And one of the things that there was some debate over was what instructions you give to arbitrators. In New York, they actually had them consider bill charges, which is a little nutty because those are just made up. Doctors and staffing companies didn't want them to have to consider Medicare. And so the law wrote in that they should consider the QPA, which is basically the median in-network rate in the market. Now, there's all sorts of, and Lindsay will talk more about this, litigation over just how much they should consider it. But that's the information the arbitrator gets.
Great. So Congress passes the law, and then it gets kicked over to the federal agencies, the Department of Labor, Treasury, and the Health and Human Services, to turn the No Surprises Act into actual rules and regulations for hospitals and doctors to follow. They had less than a year. Lindsay, looking at you here, less than a year to do that, get that done. You worked on this when you were at CMS, the Centers for Medicare and Medicaid Services. Can you tell us a story that captures the scramble that you and your colleagues were in to kind of get this guidance out in a hurry?
Sure. So let me set the stage a little bit more even.
Please.
We had much less than a year. We had a year till the rules went into effect. The law actually passed on December 27th, 2020, which many of us are on vacation on that day. And we're deep in COVID. I think I had kids still doing Zoom school, as did many other federal workers. And we had 6 months actually to get our first rule out. The very first rule was required on July 1st. And that's happening during a time of presidential transition. So the Trump administration was on its way out, first Trump administration. The new leadership was just showing up. Many of them were not in place as we were having to make critical decisions on these rules. And this would be hard in just one agency, but these rules are also overseen by multiple agencies. So we're talking about Department of Labor, Health and Human Services, Treasury, and also the Office of Personnel Management. So we are all trying to kind of figure out what this law says. Many of us have been tracking it for months, maybe even over probably years. It had been going on in Congress for a very long time, and we'd seen various iterations. But we suddenly have this law we have to implement. And normally, when you're implementing something of this level, you would be needing to get the very highest levels of leadership buy-in at each agency. In this case, they weren't even there yet. And so I remember going to, I was a career civil servant, and I remember going to one of my career leadership and laying out the challenges that we have these massive decisions that need to be made. We don't have people in place yet. And we have this clock that is ticking that's both Congress has said we have to do this. The incoming secretary has said that he absolutely wants to hit the deadlines. But perhaps more importantly, we had this time frame where we needed to get the rules in place in order to make sure that consumers were protected on January 1st, 2022. And so we had to move very quickly because we needed the rules in place, and we needed to leave issuers, plans, providers, hospitals, all of the regulated entities time to actually stand up whatever procedures they needed on their side to comply with the new rules. So I brought this issue to my leadership, and I said, like, what do you want us to do here? We have all of these decisions that need to be made. And the individual gave me some really fantastic advice. He said, look, we have to get this stood up. Let's think about it in two buckets. One is the bucket of what we need to do now to not break the NSA, to make sure that on January 1st, 2022, people can actually be protected. The other bucket is the stuff that it would be wonderful to have, really important policy decisions. But if it's not stood up on day one, it won't break the NSA. Now, there was some of that stuff where
And
nice to have, yeah.
Just jumping in for a quick second here, what I'm hearing you tell us is this was a like figure out, let's prioritize what needs to get done right now and what can we push off because we have too much, given the time frame, we have absolutely too much due all at once.
Absolutely. And some of the stuff that was nice to have, if we had an easy, clear solution, obviously we move that forward. But if it's, if we can't get there, we need to just move the rules. And I think that I personally, and I think a lot of my colleagues assumed that we would be able to return soon after those initial set of rules went out to clean up whatever we didn't quite get to in that first round, which we're now in 2026, hasn't quite happened. So just as a little bit more specific example, I think it's hard to just figure out what is going to break the NSA versus not. I remember having significant concerns that it would be hard for labs to figure out if the No Surprises Act applied to claims for lab services. The way the protections work for non-emergency services, if somebody receives out-of-network lab services in connection with a visit to an in-network hospital, the balance billing protections apply. but the lab doesn't need to be on site. The lab could be off site. And so I had lots of questions about, how are labs going to know that they are actually dealing with a claim where they cannot balance bill the individual? And so I remember raising this when I would have conversations with lab companies. And every time I raised the question, I was told, nope, this is not an issue. So even though I thought this was an issue we needed to figure out to avoid breaking the NSA, I thought, okay, I'm hearing from the people who actually have to implement this. This is not an issue. That's in tier two. And I think, those who have followed the NSA closely have really seen that one of the huge challenges in how the NSA actually was implemented is there has been massive confusion about which claims are eligible for the dispute resolution process that Zach just talked about, or even for the eligible or even subject to the No Surprises Act at all. So, even though the companies I was talking to assured me they're confident they can deal with it, perhaps that wasn't an issue we should have put in tier two or bucket two. It seems like if we had had the ability and the time to develop a solution that would have worked elegantly for labs, that may have had spillover to all of these other providers and entities that have struggled to figure out if the No Surprises Act applies to a claim. Maybe if we had more time, if I had stuck with my gut that this would be an issue, we would have actually been able to work through those issues on the front end instead of having to deal with them after the systems went live.
I feel like your story really does a nice job of illustrating just the kind of time crunch and pressure, and even people with the best of intentions who are trying to sort things out. The reality is, new legislation means new things. Everybody's got to figure out something new, and it's hard to anticipate exactly what that's all going to look like. Just briefly, Lindsay, what did you? Because I want us to kind of get to the meat of move beyond the story, the history, and move into the now. What did you think of the suite of rules that you all ended up releasing in 2021? Like, were you stressed on time? How do you think you did? And again, just briefly.
Stressed on time, absolutely. I actually think we did a really good job with the time we had in terms of protecting consumers, as I think you laid out at the beginning of this webinar. I think we did a really good job in that. I think which should have been and was at least my number one priority, to make sure consumers were protected from the balance bills that they're supposed to be protected from. And I think we really did that. I think that the rules that we actually adopted would have put downward pressure on prices and achieved many of the cost containment goals of the No Surprises Act while protecting consumers. However, as I'm sure we'll get into, they have not been implemented as intended. I think if they had been, we wouldn't be seeing such a high percentage of disputes going to providers. We certainly wouldn't be seeing, I think, such high award amounts. But that is not how the rules were implemented.
And so just like super simply, like in one, if you're going to grade this, what grade would you give it?
Ooh, I hate assigning grades. I would grade it on a curve to.
This is why I don't let my students grade their own homework, Dan.
Yeah, I'm new to academia. I haven't had to assign grades yet.
This is like my student's dream.
I think that we did it in the time we had. I really do think we did a fantastic job, but it was not perfect. It couldn't have been perfect in that time frame. So I'm going to go with a B+.
Okay.
Although I have feelings in both directions on that one.
You mean like it could be both better or worse than a B+?
I feel like the curve for that time frame should push it up, but I also really think that there is a huge value to giving an opportunity for notice and comment rulemaking, where we actually could have proposed the rules and gotten feedback. And I know that if we'd had that opportunity to really put out to the public what we were proposing and got feedback, identified other issues, addressed those issues in the final rule, I know we would have come out with a much better product. But the timeline just didn't allow for that.
Very good. So, and one more here quickly, Lindsay, to you. Like, as soon as you guys released the rules, providers started challenging them in court. There have been some 20 lawsuits against the law by one count. Half of those centered on the arbitration setup. Nicholas Bloom in the audience asked why there aren't more controls in this process. And my understanding is this litigation is part of the answer. What impact have these lawsuits, Lindsay, had?
I think it's hard to overstate the impact of the lawsuit. So let me just sort of walk through the rules quickly. The very first rule that was issued around the arbitration process basically said that you begin with the presumption that this qualifying payment amount, or QPA, that Zach talked about, which is about equal to the median, it's roughly supposed to be the median of the in-network rates. You begin with the presumption that that's the appropriate out-of-network rate for the claim. And the arbitrator is supposed to select the offer that's closest to that QPA unless they determine that there's information submitted by either party that clearly demonstrates that the QPA is materially different from whatever the appropriate amount is. So if those rules had gone into place, that sets a pretty clear standard that the QPA is supposed to anchor the decisions. So that rule gets challenged. It's challenged so early that we haven't even seen how it would play out because the process has not gone into place yet. A judge in Texas who has played a very big role in the litigation around this, most of the cases that have struck down the rules have come out of his court, strikes this down. So the agencies scramble because we need this to go live. And there's a second rule issued. And so that rule pulls back a bit, but it still does hold on to the QPA as a major factor. And I think that if, I know the court case has said that this should not be the case, but I think if you look at the statute, there's a very strong argument that this QPA amount was intended to serve a big role in the NSA implementation and in the arbitration process. So under the second rule, the arbitrators are instructed to basically take the offer that best represents the value of the item or service after they consider the QPA. So they kind of consider the QPA first. And then they also should consider all the other information that's submitted, unless it's in a few of these prohibited factors that they're just not allowed to look at. So they first look at the QPA, and then they're supposed to say, okay, here I got this other information. Is it already factored into the QPA? The QPA is based on contracted rates, so is it somehow already baked into the QPA? And if not, okay, is it credible information? Is it relevant to the offer? Things that, I think make sense in terms of should the arbitrator actually give any credence to this information. And then they take all that information into account and they figure out what the best, which offer best represents the value. This also was struck down in the same court. It was challenged immediately and struck down. So now we're in a situation where I think the agencies probably feel very, very constrained in offering any kind of guidance to the arbitrators in terms of what they should be considering or how they should be considering the QPA. On top of that, we've had litigation on the QPA methodology itself. So while there was one case where the court upheld the methodology and said it was an example of great rulemaking, really consistent with the Administrative Procedures Act, we've had this other court decision, same court as before, that has said a number of the provisions in the methodology are illegal. That's continuing to be appealed, but it also throws into doubt, I think, a lot of it raises questions about the QPA. So we have very little guidance for the IDREs, and the QPA is sort of tainted at this point.
And so one sentence, I want to bring Ben in here, and I want to kind of fast forward to today, but one final, in one sentence, Lindsay, would you say something like these lawsuits have really sort of almost like neutered the arbitration process? We actually haven't seen the arbitration process work in the way it was set up to because of these lawsuits. Like, what's the one sentence takeaway here on the impact these lawsuits have had? One sentence.
The litigation has transformed the arbitration process into an extremely provider-friendly environment. I don't think it has neutered it. I think it's made it very provider-friendly.
Fast forward to today, and while the consumer protection piece of the No Surprises Act is working quite well, as we've established, the arbitration process, as Lindsay just laid out, is not working how Congress envisioned. And as Rachel highlighted at the top, providers winning 80+% of cases, and usually winning nearly 3 times the average in-network price for a given procedure. Ben, you've been trying to understand why this is happening, something Jesus Vasquez and many others in the audience are eager to hear more about. What has your research, sir, found?
My research has looked at the arbitration process itself that Lindsay and Zach so eloquently teed up. And it's worth maybe thinking about the arbitration as what it could have been versus what it is. And I'll use a metaphor that I kind of like.
Love metaphors.
So the arbitration process is kind of like two people bidding on a trinket on a trinket on eBay. So we're both bidding with one another. Dan, I want to outbid you, but not by so much I'm leaving money on the table. So this is trade-offs. So here's a trade-off in this kind of game. I want to outbid you by just enough that I win, but not make me look so greedy that I'm never selected. So when the insurer and the doctor group go into this arbitration together, they're each making that trade-off when they're formulating their final bid. And so in a perfect world, what you would get is they would think about, oh, well, if I'm too greedy here, if I'm an insurer and I offer too low an amount, I'm never going to get selected. If I'm a provider, I'm too high, I'm not going to get selected. That market force would drive us to the would have been market rate. Now, what if the arbitrators here have an opportunity to make some money in the process too? So I have on my other screen in front of me the amount of money an arbitrator gets from each and every individual case that they take. So on the low end, it's about $300-400. On the high end, it's $800-900. And Rachel put three big numbers up at the beginning of the talk: 20 million. So 20 million potential out-of-network medical bills if about 1 million or 2 million a year, which is the number of arbitration cases we see, are going in front of the arbitrators. Multiply that couple of $100 times 1 million cases, and all of a sudden you have an opportunity for the arbitrators themselves to do quite well. Now, more cases are going to come to the NSA if they're particularly favorable to one side or another. And what we're seeing is consistent with a story that looks like that.
That looks like what?
I'm going to use a word from the economics world called inducement, meaning I'm inducing someone to do something. We have a regulatory system at play that induces the arbitrators to bring more cases, to kind of be, to, there's, now I'm not an arbitrator.
Well, let me jump in. I think what you're saying to me here is I should quit my job at Tradeoffs and become an arbitrator.
Dan, I love what you do, and I would be sad if you quit your job at Tradeoffs, but I'm not telling you don't do it. Not telling you don't do
it. And so, like, what you're painting a picture here of physicians winning big, arguably gamey. Well, let me dial this back. So the arbitrators have an incentive. They're being induced potentially to take more of these cases. The broad picture we have, though, right, is physicians winning big. Potentially some, and when we say physicians, we're talking, many of them are employed. We're not talking about a doc who's hung their shingle out there, but the entities that own these practices, these physician practices, potentially gaming the system to increase payout. One important thing to note is that the vast majority, about 3 in 4 of these physicians, sorry, I've already said this, are now employed by hospitals, insurers, or private equity firms. With that in mind, Kelsey Burke wants to know, what would you all say to providers who think the process allows them to get what they should really be paid? What do you think, Ben?
So I'll answer. This is the reason why an arbitration system that isn't clogged up with cases could be beneficial. Because if the provider really does have a reason to get paid away from what the median in the market is, they can come to an arbitrator and kind of make that pitch. But with 1 million cases every 6 months, it's very, very difficult for that to get through.
Zach, thoughts on this question?
So I think we need much clearer instructions for arbitrators. I think we need, in a sense, a review process for them. And that will require us specifying what we think good arbitration looks like. I think it is right that if the case was wildly atypical, the physician should absolutely get paid more. If it's your standard visit, probably not. And so what we actually see, and Ben can talk a whole lot more about it, certain companies, physician staffing companies, basically submitting all of their stuff to arbitration. And that was never, I think, the intention of the law to begin with. We also see, really curiously, some ownership stuff that should get us all concerned. So when the same financial firm owns the physicians and owns the arbitrators, at a minimum, like, that ain't a good look. So I think we got to get rid of that. I think we need instructions for arbitrators. We got to shift their incentives, and I think we got to start, doing some grading on them and think about whether we want to renew their contracts.
And thanks for that, Zach. Ben, on that point, based on the research you're doing, in my question, I used the phrase gaming the system. Based on the research, based on the evidence in front of you, would you say you're seeing what looks like to you providers gaming the system?
I'm going to be sober about the facts that I'm seeing. I'm seeing that the median arbitration award is higher than all but 1.5% of any negotiated price. So these are rates that are almost never found in actual market negotiated processes. I'm also seeing
and wait, sorry. Before you go to that, and also, what does so break that down in a simple way? What does that mean when you say you're never seeing prices in all but like the most rare of instances in the market?
Using the transparency and coverage data, which is new data that's come out under price transparency rules and regulations, we can look at the actual prices that are paid in these markets, and only 1.5% of those cases, a very, very small fraction, are as high as the average amount that comes out, the medium amount that comes out of these arbitration cases.
So that tells you what?
They're on the far, far end of extreme for provider reimbursement amounts. Now, maybe some of that elevation is warranted by the facts of the case that are allowed to be brought into arbitration, but this is a particularly high number, and they're happening millions of times. And insurers are not often winning in these arbitration cases when they bring these arbitration cases to the dispute resolution entities.
Now, one thing I do want to caution us on, Dan. So this is a little like if you Google side effects, you find a bunch of people who report having side effects. So I was looking at a new car. I went and looked at reviews for it on Reddit, and it turns out like lots of people have had bad experiences with this car. Well, that's because the people who have bad experiences go to Reddit, and people who have good experiences don't go to Reddit. They drive their car and they're incredibly happy. So I think we don't quite have the full picture yet. So I think Ben's work has told us something very clear and very important, which is that when these cases go to arbitration, providers are getting a lot and they're winning most of the time. But in some ways, that's like kind of not surprising. I think it was always going to mechanically look this way. So you wouldn't take a typical case to arbitration. Right? If I had a typical case, chances are I'm going to settle that. Now, I think what we need to know are two things. One, I think Ben showed us. The other is out there. I'm working on a little bit right now. How has this affected total spending on emergency room services? Right? Because in New York, what we know is that slowed the growth rate in emergency spending down. And we just haven't seen great work on that yet. It's also pretty tough to measure. The second is whether there are entities that are clearly abusing the system. Now, we then have to make the decision about whether the abuse forces us to change our opinions. But the New York Times did this expose about we got David Rowe, the plastic surgeon who's, whatever, I'll just say it. I mean, the guy's gaming the system and getting hundreds of thousands of dollars for cases, which he should not be getting hundreds of thousands of dollars for. There's a person who used to be on The Apprentice who Donald Trump fired for being too vicious. Think about that, right? And that person's just bringing litigation at an industrial scale. That probably isn't right. Now, for the other cases, I think we need to look at it more.
So I'd like to turn to solutions. I think you're alluding to that, Zach. Lindsay, you have. Ben, you've studied states that have separate surprise bill protections. Peter Newell is curious about states' role in all of this. You singled out to us in background conversations, Ben, that Washington State is a place that's finding some more luck here. What's in the water in Washington? Which I think is a question I asked you 3 years ago when we did this story.
Yeah, thanks for the question, Dan. There are some other states that have chosen to use their own dispute resolution system for these surprise out-of-network medical bills, and they are not seeing the runaway volumes nor the high payment amounts that we're seeing in the No Surprises Act. They publish a lot of data. They arm the arbitrators with a lot of that data. But I think Zach alluded to this point before when he mentioned looking back at the arbitrators who we've already certified. It's not losing sight of the minutia in the rules of, hey, we can actually make sure that the arbitration entities we certify are up to standard with what we're looking to see in dispute resolution. And so when you look at the outcomes in Washington State, you see at most a couple hundred disputes a year rather than the order of a magnitude of millions. So that's what I've seen in looking at the states.
And so if there's one thing that you're seeing, if there's one thing that the federal system could graft from the states, it seems to be the most effective, what has it been?
Looking back at a regular basis on who were empowering to make these decisions is a worthwhile exercise, not necessarily one that comes out of Congress, but comes out of the agencies themselves.
I want to go around the... Sure, go for it, Lindsay.
If I could just jump in here. So I am not an economist. I am a lawyer, but when we were initially looking at kind of thinking through how we would implement this, what numbers to expect, which we got massively wrong. One of the things we were seeing was that in states where the win for provider, the whatever the process was that they sort of set up, leaned towards the providers and at higher numbers, it created more of an incentive for providers to bring whatever the case was, bring it to whatever process the state had. And so I remember looking back at the numbers then, and if I recall correctly, you just saw huge growth of the number of disputes that were in those states, whereas in other states where it was more kind of even, you didn't see that same growth. And I think that, well, I completely agree with Zach that we need to get a better understanding of what's really going on and what the true impact is of the No Surprises Act over everybody. I do think it's noteworthy that we are seeing that real increase in volume, and we're seeing huge volumes in the No Surprises Act in a world where providers are winning. They have every incentive. It makes a ton of business sense for providers to go when they see those sorts of wins. And so I think my concern is that we really are only seeing the beginning of the impact of the No Surprises Act. If it sort of follows that growth rate, I remember looking at early on the volume of disputes and everything in IDR. I think we're just at the very beginning of where the NSA leads. The other thing I did want to highlight while we're talking about solutions is you mentioned that some states have this in place. Any state could adopt a law that does set the out-of-network rate so that plan disputes that are subject to their jurisdiction go to that state process instead. That doesn't cover everybody. Self-funded employer-sponsored plans are not going to be subject to that. Probably isn't going to reach a case where the providers in one state and the plans in another state. But that is a sort of a safety valve states have to control costs within their own state if they're not happy with the direction of the dispute, the federal arbitration process.
And so, go ahead, Zach.
No, please. I mean, I was just going to say, look, let's talk about four, I think, pretty common sense things that could be done really quickly. I think the first is just saying, look, you can't have conflicts of interest, right? You cannot be an arbitrator ruling on an entity who's owned by the same company as you. Right. I don't think you're going to get a whole lot of pushback on that. We should see if it's happening. If it's happening, those entities should just be disqualified.
And real quick, Zach, sorry, before you go to number two, is there any evidence of that conflict of interest? Do we know that that's actually happening?
Yes, that is
explain that.
So it'd be a private equity firm or another. I don't want to vilify private equity in this, but let's just say a private equity firm owns a physician staffing company. And in its portfolio also owns a company who's doing arbitration. So the same parent company owns the arbitration and arbiters, and then owns the physician. So at a minimum, they're getting a whole lot of inside information about how these processes are playing out. That's at best. certainly there's a conflict, and then there's the scope for that to play out. One of the things I want to see Ben look at is, I don't know if he has it in the data, but what are the patterns we see across arbitrators? Like, how much variation do we see? Are there some arbitrators who are better at this and worse at this? And that really gets us to my next three recommendations. So the first is we should be auditing the arbitrators. Like, we should be saying, here's how these folks do. Here's what this one does. Here's how this one does. And then third, we should have a set of rules for contracting with them in the future. Now that's going to be tough, and we have to think about that from a rulemaking process. But the contracting shouldn't just be that you sign up and say you can do this, get your $500, and off you go. Do we think you're good at doing this? The final one, and I think this is incredibly important, are penalties for arbitrating on cases that weren't eligible in the first place. So there are cases that are going through arbitration where Medicare is the payer, right? That's just nutty, right? And because these things are binding, they go to the courts, and the court's like, oh, we can't do anything to change it. Like, the law says, once these cases that are ineligible go through and there's been a ruling, the payer's got to pay. And so I think we need penalties for the arbitrators to do that. So we got to think a lot about how we're contracting these entities. We got to audit them. We got to get rid of the conflicts. And I think hopefully that gets us closer to the world that Ben's describing. The research that I saw from New York that I did that showed that it lowered spending, because I think right now it's just not working as well as it should.
Lindsay, there's a question from Peter Werewine. If you were to advise Congress on how to address solutions based on the evidence, what would you tell them to do?
So I think a lot of what Zach just outlined is stuff that it would be really, really good for Congress to address. Agencies, maybe they can audit the IDREs, the arbitrators now, but what standard are they able to hold them to when the litigation has basically said you can't direct them to do anything? So Congress should, at a minimum, really step in, I think, to restore that authority to the agencies. I think Congress has a number of options that they could take, and with varying levels of impact in terms of cost. They could adopt a rule that puts in place the types of rules that the agencies originally adopted. They could adopt a benchmark approach, even though that was originally rejected. They could take some of the transparency and coverage data that Ben was just talking about and set a new benchmark based on that. They could address the incentive issue that Ben has talked about in terms of the IDREs, and change the way fees are collected so that there are fewer incentives in place to try to attract more cases to the dispute resolution process. So there are a number of steps that they could take, but I think at a minimum, having them step in to give the agencies authority to direct arbitrators and oversee arbitrators more directly would be incredibly helpful.
And when you just one quick follow-up before we get to you, Ben, to hear about thoughts that you have about solutions. If there were to be that greater oversight, Lindsay, what would you anticipate if you were in Washington, you were advising lawmakers, what would be the anticipated outcome from this greater oversight in your mind?
Yeah. So I think that's a great question, which is why I think, if you want to, if we're looking for a solution, which I think would be best, that actually puts puts the NSA back in a position to put downward pressure on prices so that we can kind of address some of the affordability issues. I think the direction needs to give the I think that that Congress would really need to give the departments the authority to oversee IDREs. I keep using the term IDREs, arbitrators, the ability to really weight a benchmark approach, and whether that's the QPA or a new number that is more politically palatable at this point, I do think it needs to be anchored, because otherwise, you could see the direction going in different directions. You could see the departments being shy given all the litigation and how aggressive providers have been in litigation, or at least certain providers. So you could see a world where direction is not enough to really bring kind of order to the arbitration process. If Congress wants to actually have some sort of cost saving impact for the NSA, I think they need to adopt a benchmark approach, either a direct benchmark where this is the payment that is being paid, or one where the arbitration process really is anchored to that benchmark.
And I want to end the conversation by moving beyond the No Surprises Act and using this as a case study for policy making. This is
Yeah.
a very popular bipartisan piece of legislation that now has some very real unintended consequences. Bill Durham asks, what lessons does this experience offer future policymakers, researchers, and advocates on how to avoid unintended consequences? Ben, let's start with you.
So I really love Zach's point about looking for conflicts of interest or potential conflicts between arbitrators and the firms that are coming in and deciding cases. And the lesson there is we should look for little wins where we can find them. And there are lots of low-hanging fruit and solving the kind of broken pieces here. And just to plug Zach's 1% policy initiative at Yale, these are exactly that. It's looking for these kind of 1% plumbing the leaks up where systems are broken. These are really, really thorny issues. It's about deciding what the right rate is for a contract that otherwise had not been set at the beginning of the year. And so these knots are hard to untie. Looking for the little wins where we can find them is quite important work to be done.
Right. And so that's potential solutions. But be going, well, let's stay here for one more second. Are there any other solutions that you would like to see coming from Congress, Ben, before I ask this sort of like broader, more meta question?
I'm an economist and not a political scientist, so I want to punt on this a little bit, only to say that my sense is that beyond Congress, a lot of the activity will come from the administration itself and from the agencies, because so much of this law that was passed with bipartisan support, Congress has said, look, we solved this. We got our wins when we got them when we passed this thing. Let's move on to the next piece, and have left wonks like Zach and Lindsay and myself looking at the pieces on what's happening with prices. And one way to think about what's going on here is, even if you can't exactly quantify the equilibrium effect of the law, or in layman's terms, how much prices are or are not going up from it, one way to think about the No Surprises Act is as insurance itself against surprise bills. So we may all be paying higher insurance premiums as a result of this, but we've also removed ourselves from the likelihood of being stuck with an unexpected out-of-network medical bill. Is the price we're paying, so to speak, for that insurance, is it worth it? That's where the hard work that we're all doing here is kind of hopefully coming to bear.
Okay, very good. Thank you. So with this meta question, right? We have this very popular bipartisan piece of legislation. Uh, People were psyched. I remember reporting on this. I remember interviewing you, Zach. There's a
And
lot of
I'm still
enthusiasm.
psyched, by the way.
Great, great, great. At the same time, we're seeing these like super unintended consequences that are they're kind of ugly. And so this question is like, what lesson does this experience offer future policymakers, researchers, and advocates on, are there ways to avoid unintended consequences? Zach,
So,
thoughts?
yeah, so I'm going to give 3 points. So, first, I do want to say that we have to be cautious. I think it is actually probably too soon to sort of say this thing is hurting people and we got to go back to the drawing board. I think patience is a virtue on this one, and I don't want to see us act too quickly. But I think 3 things in practice that we should be taking from this going forward. The first is policymaking shouldn't be one and done, right? That is, Congress votes on the thing and moves to the next issue, never to look at the issue ever again. This is like a long-term committed relationship, right? Once you sort of married and entered into your nuptial bonds, like you are with this issue for the long stretch. And
You need counseling.
you need counseling. Well, you need to keep communication open, all the things. But truthfully, and getting serious for a second, you probably have to revisit laws, and you find something that isn't working and you fix it. And I think one of the challenges is that right now in this hyper partisan environment, folks are they're just scared to open the hood on what's happening. So that's number one. The second is, look, I actually think we're on the precipice of another set of big health reforms. So every 10 to 20 years, we get big health reform in the US. And if we look back at the reforms we had of the last 50 years, most of them have been about expanding coverage, right? They're addressing problems of scarcity, too little coverage. The next one's going to be about affordability. That's a problem of excess, where the solution is, in a sense, to do less, to take away. Those are really hard problems of excess for democratic institutions to solve. And there's a member of Congress out there who looks at the No Surprises Act. And when you ask him about it, he says, look, people are protected. As long as people are protected, I don't really care what providers get paid. That's how we end up spending 18%, and we're going to end up, if we follow his path, spending 25% of GDP on healthcare. Which takes me to the sort of third point, which is, economists have a minimalist approach. So when I see a problem, I'm very reluctant to deviate from the sort of competitive equilibrium. Say, I like competition. That's why I like arbitration. I think the question a lot of the folks who are out there listening, folks on this panel, have to think about is, does the policymaking process, has it gotten so sort of bent out of shape at the moment that instead of doing the minimalist approach, we got to move towards a more maximalist position, which would look like price regulation. I'm not totally there yet, but one of the lessons from this for me is that if you proceed incredibly cautiously and take that minimum approach, you open the door for what we've seen here.
Final question to you, Lindsay. 2 minutes. What do you think of what Zach just said?
I agree with a lot of what he just said. I think it really takes time to make good policy. And I would just add on to that. I think that we've been talking a lot about the actual nuts and bolts of what policies were put on the books. We haven't talked about how things are operationalized much at all. And that also takes time. And I think that you can look at a lot of what's going on in the No Surprises Act and a lot of the challenges that we've seen and see operational problems. We're taking two groups that didn't communicate with each other. One was an out-of-network provider who purposefully didn't stay in touch with the plan issuer, and we're forcing them to communicate in a way we never have before, and didn't really have systems in place. We still don't have systems in place for them to communicate. So I think I don't want to be too patient, because I think that we are overdue to fix some of those operational problems. But I do think that we haven't yet seen what the No Surprises Act could look like in kind of that world where we have figured out how to implement it smoothly. And I think building in time for the policy to develop, it would have been great if we had more time, as I think I've made very clear, for the policy to be developed at the agencies, to then have more time for parties to operationalize it. All of that would, I think, help with a much smoother rollout of the No Surprises Act or any law.
Thank you, Lindsay. Let's leave it there. I just want to say a quick, too bad that the audience can't, if the audience were here, I know they'd be snapping or clapping or hooting or hollering. The three of you have done an excellent job. We really appreciate the time. Thank you very, very much. And I also would like to take a second to give a special thank you to my partner in this Decoding the Moment series, Rachel Werner. This is Rachel's final event as she transitions out of her role at LDI to spend more time on research. Rachel, this might be our last Decoding Moment together, but I'm very excited to keep working with you in one way or another to make sure people can together make so that we together can help people make sure, I apologize, so that together we can help people make sense of our complex health policy world. If you want to stay connected with Tradeoffs and LDI, and we hope you do, you can find links on how to do that in the chat. Also in the chat is a link to a recent episode we did with New York Times reporter Margot Sanger-Katz about her reporting on some of the providers making big money off the No Surprises Act. If you enjoyed today's conversation, I highly recommend you check that out. Finally, you'll also find a link to a survey in the chat. Please take a second to fill that out. It makes a big difference for us. Thank you all for being here. Thank you all for joining us. And one more time, Rachel, thank you very much for being a part of this very special series. Take care, everybody.